Hey everybody, it's Dr. Jensen, and welcome back to Module 5, Media in Courts, Part 2. So this lecture we're going to go deeply into media trials and talk about some more examples of what we mean. So let's get started. Alright, so first we will introduce to you media trials, and then look at some famous media trials in particular to help illustrate it better. We'll also look at media trial effects, and then the merging of judicial news with entertainment. And finally, we'll talk about some of the Supreme Court cases about live television in courtrooms. So let's jump in. So what is a media trial? Well, when you first ask somebody, they say, you know it when you see it. But to be as definitive as we can, it's really a regional or national crime or justice real-world event in which the media kind of co-opt the criminal justice system as a source of drama, entertainment, and profit. How long that coverage is, how extensive it is, and what is covered varies, as you might imagine, but again, it is kind of one of those things where you know it when you see it. It really dominates the national news media storyline for a while, where people have heard of it. It's pretty pervasive. So basically, the social construction of selected trials as infotainment products are really commodified and mass marketed, again, across many mediums. So coverage is live whenever possible, and you mostly see pictures preferred over text. Sometimes you see statements as kind of blown up blurbs that get kind of front and center on the screen, but mostly people are interested in reactions, emotional response, facial expressions, and the content is characterized by conjecture and sensationalism. There's lots of commentary on these trials, which the commentary almost takes a higher priority than the actual witness statements, opening arguments, and rebuttals. It's almost ridiculous. So if media trials teach us about courts, then this would be equivalent to learning about geology only through volcanoes. It's surface level eruptions that don't represent everything. So that analogy was brought to you by Surratt in your text. And I think it's a pretty good analogy to think about. So first, we have these notorious media trials that took place after the establishment of the first mass media, which, as you know from reading your textbook, was around the 1830s. But again, we didn't have a lot of photographs at the time. It was very primitive and mostly through print. However, in recent times, there have been a consistent presence in the media. You'll see a great big media trial at least every 2 to 5 years, if not yearly sometimes now. It's been increasing in frequency as of late because of how popular they are and how newsworthy they are deemed. And especially as news outlets are competing for ratings. They try to scoop each other with having more inside information. And again, you see frames typically found in entertainment. They vilify people, they make other people heroes. You have kind of the little guy overcoming things, the underdog, and you have kind of corrupt, privileged, rich, evil people. You see lots of the same caricatures and stereotypes. They also use backgrounds and insights and interviews beyond the trial. And again, it gets almost ridiculous. They'll go, let's now talk to the college roommate of the defendant. Well, they probably haven't talked in 20 years. Tell us about their personality. What are they like? Now we're going to talk to the kindergarten teacher of the victim, blah, blah, blah. And I mean, they are just grasping at straws, really reaching for any little tiny insight that somebody might find interesting. And again, that starts to become more pervasive than the actual courtroom proceeding, which becomes a very lopsided version of the coverage. So again, media trials are distinguished from typical judicial news of reports on courtroom verdicts and so forth by the massive and intensive coverage that begins with the crime or the arrest, or fleeing the scene. You know, we'll talk about all kinds of events that start to say, oh, that's newsworthy, we should watch it unfolding before our eyes. So this is a list of famous media trials. I'll briefly cover a few of them, and you'll find this list in table 6.1 in your textbook, and we'll kind of gloss over a couple. So you have the Lindbergh baby kidnapping, which was one of the trials of the century, if you read legal history, where it was a kidnapping murder of the baby of Charles Lindbergh. Many students probably wouldn't have been alive during the Rodney King trial, where it was a beating of a black man by white police officers, which kind of started more modern conversations on police brutality, and then riots that ensued after the verdicts of not guilty were made. And then certainly the infamous O.J. Simpson trial of the murder that he was alleged to commit. And then more recently, Casey Anthony, which Casey Anthony was discussed in the last module with all the different forensic evidence that came forward. And then again, she is profiled in your chapter. Jeffrey Dahmer, we'll talk more about that later, Scott Peterson, Dennis Rader, Timothy McVeigh, the infamous terrorist that bombed the Oklahoma City federal building, the Murrah building, and Jodi Arias. So these are some of the more famous media trials that we'll mention in the textbook. So I talked briefly about them, but I really encourage you to look these up in your textbook. If not, read some Wikipedia and other accounts out there of them so you're familiar with why we would qualify them as a famous media trial. So what are the effects of media trials? So this is the quintessential question. Do attorneys, judges, and other participants react to the presence of television cameras by altering their courtroom behavior? This is what we might refer to in modern day as reality TV behavior, right? So I'm going to perform myself a little differently because the cameras are rolling and I want to be socially desirable and represent myself the best, not having to save face or make myself look bad, okay? So that's kind of the question that we're having to wrestle with here, and that we definitely wrestled with years later with the Supreme Court, and we'll talk about where those cases ended. So again, there is that question. It may affect the behavior of legal actors. Prosecutors may act overzealously, overly dramatic. Judges may treat the jury differently, being much more kind of strict or sometimes even abrasive with instructions. They may interfere with legitimacy in the criminal justice system. If people are altering their behavior, it's not as authentic and genuine. Another thing we deal with media trial effects is the social construction occurring in media trials. So essentially, crime is attributed to individual failings of the defendant, their character, their own flaws and weaknesses, rather than social conditions with the environment of what happened in the context of the crime scene, interactions with others, or even social institutions, which again can be a little bit inaccurate with what happened. We also see narratives taken from the entertainment media. There's three main narratives that Surratt talks about, which we're going to go over in detail. The abuse of power narrative, the sinfully rich media trial narrative, and evil strangers narrative. So first, the abuse of power. So essentially, this is a case in which the defendant occupies a position of trust, prestige, or authority, and the higher ranking the person, the more media interest there is. And we see this with the Rodney King beating, the Bill Clinton impeachment, and Bernie Madoff. Let me tell you a little bit about Bernie Madoff. So essentially, Bernie was a former chairman of the NASDAQ stock exchange, and he was accused of securities wire and mail fraud, money laundering, theft, falsifying his SEC statement filings, and perjury. He had a massive Ponzi scheme investment operation and was estimated to have cost his clients billions of dollars. The verdict in his case was that he pled guilty to 11 felonies and was sentenced to 150 years in prison. As for the Rodney King beating, 4 Los Angeles police officers were accused of using excessive force in arresting Rodney King following a car chase. The acquittals in the state trial triggered riots in Los Angeles, leaving 53 people dead, more than 7,000 people arrested, and more than $1 billion in property damage. The verdict in that trial was, in the first state trial, the jury acquitted 3 of the officers of all charges and was unable to reach a verdict in one charge against the 4th. In a subsequent 1993 federal trial on charges of violation of civil rights, a federal jury convicted 2 of the officers and found the other 2 not guilty. No disturbances followed that verdict. But then let's talk about a few others when we do these narratives. So the sinfully rich narrative. These are cases in which socially prominent defendants are involved in bizarre or sexually related crimes. And essentially the theme here is that they should know better. They're this person in front of the public and they think the law doesn't apply to them. So we're kind of curious because we don't have access to socially prominent people because of all the gatekeepers and privacy things they have. The only view we have into their lives are afforded through the paparazzi. So it's fun to see them in a view that's not a paparazzi view, and that's where the entertainment value comes from. So first, let's talk about Sam Shepard. So Sam Shepard was an Ohio doctor who was tried for the murder of his wife, and his verdict was that he was found guilty by the jury of murder in the second degree and sentenced to life in prison. Shepard won a retrial later in 1966 after a successful U.S. Supreme Court appeal argued prejudicial impact from news coverage surrounding his first trial. He was acquitted by the jury in the second trial and died in 1970 at the age of 46 of liver failure. So this is where the Supreme Court saw there was significant intervention by the media that impacted the trial and the fairness of it. Another one we're going to bring up is Paris Hilton in more recent years. So her trial as an American heiress, socialite, and reality television star, that she was described as being famous for being famous. She was first arrested in 2006 for a DUI and began a series of persistent, less than felony rated judicial proceedings. Hilton pled no contest in 2007 for reckless driving, and she was placed on a 3-year probation and fined $1,500. She was again arrested in 2010 on suspicion of cocaine possession in Las Vegas. Her verdict was she was found in violation of that probation in 2007 and sentenced to 45 days in jail. She pled guilty in connection to her 2010 cocaine arrest to 2 misdemeanors, sentenced to 1 year of probation, a $2,000 fine, and 200 hours of community service, plus a drug treatment program. But again, this is kind of where we see celebrities gone bad type coverage. And again, it's a playful narrative that is very, very exciting and interesting to the public. Our final narrative we're going to look at is the evil strangers narrative. Okay? So essentially, this plays out in 2 ways, and we'll do a few examples of each way. First, non-Americans. So these are trials involving members of minority groups, sometimes immigrants, counterculture groups, or political activists and advocates. So they're seen as different than the rest of society and a threat to everyday freedoms. So again, Timothy McVeigh is a more recent example of an accused terrorist that was very anti-big government. Okay, we're going to bring up one other, and this has to do with the Lindbergh baby kidnapping. So Bruno Hauptmann was a German immigrant accused of the kidnapping in 1932 of Charles Lindbergh's baby and the murder of his infant son. He was found guilty and actually electrocuted in 1936. Again, we also see psychotic killers in this evil strangers narrative, these people that are so different from us and they're a threat to society. The focus is on their bizarre murder cases in which the defendant is portrayed as maddened and a predatory killer doing strange, maybe even disgusting things. So first we'll talk about Ted Bundy. I don't know that there really is much to say. He's so pervasive in the media, raping and killing so many women over so many years. Certainly there are current documentaries that give insight into his life. And we have this intrigue with psychotic serial killers in American society. I'm not sure why, but it's like we have to figure them out and we have to know how this works to try to prevent it. But Jeffrey Dahmer, you may be a little less familiar with than Ted Bundy. So in 1992, he was a cannibalistic serial killer who preyed on young men in Milwaukee from 1987 to 1991. And he was accused of killing 17 men and then saving their remains and eating them. He was later sentenced to 15 consecutive life terms because his killings were so grotesque. He was actually killed in prison by another inmate in 1994. We'll talk briefly about Dennis Rader. Dennis Rader was known as the bind, torture, and kill, that's where BTK comes from, or the strangler serial murderer accused of killing 10 people in Wichita, Kansas over almost 20 years. He pled guilty and received 10 consecutive life terms. So when we merge judicial news with entertainment, really media trials are the merger of these 2 areas. So essentially you have multimedia products and really extensive exploitation, deep coverage into their lives of defendant and victim if the victim's still alive, or at least the surviving family. This is also where we get internet coverage, which provides interactive commentary where you can send and like and share and provide feedback on what's going on. This also attracts audiences to maintain an objective stance. They don't have all the material. They don't have everything in court. They have a perception or a narrative or highlights of what happened in court, so they don't have all the details. These are ready-made narratives for entertainment and participation, and this influences the public's attitudes and views regarding the crime, justice, and society for years. And so the first concern we have is legitimacy concerns. So it's very common that a highly publicized trial will help the public form an opinion on guilty or not guilty verdicts. And if it goes contrary to what they think should have happened, then we start to challenge the court and the entire court process itself. But again, we are making our decision on limited information provided by the media. We don't have court transcripts, and we don't know all the evidence that was allowed or suppressed. We just have kind of those highlights. And so then we start to question how fair the court is, or how could they not convict that guy? He's so guilty. We start to do these public outcries. The second effect that we have is what we call a secondary effect on non-publicized cases. So it's not the main concern, but if your case is similar to one that has a media trial, but it doesn't get much publicity, then we start to wonder what effects it's going to have on there as far as it being deemed important, or people making the same claims, or basically having the same outcomes as the media trial, pulling too much similarity or significance and not letting due process establish the course of events in the crime. So we're going to be wrapping up here with live television in courtrooms. So at first, this was deemed the most intrusive media interaction with the judicial system, where you're just right there in everybody's faces, filming every expression, every reaction you can get, and then editing it for the most exciting parts. So first, Estes versus Texas in 1965 was a Supreme Court ruling that banned TV in the courtroom. And you remember we brought up that other case, which was the Sam Shepard case. And that is, again, part of the environment we were dealing with, where we thought that maybe we shouldn't have TV in the courtroom. So television was unavoidably disruptive and should have been banned, and we thought it had undue influence on the case, where it was really pervasive and aggressive in its filming. Now later on, this was overturned in Chandler versus Florida in 1981. So basically, it was deemed appropriate to have less intrusive television, where a judge could justify any filming restrictions in advance, like you can show the defense, you can show the prosecution, but you can't do close-ups of faces. You can't show the jury at all. You can show my face, but only during the end of the trial, or only after deliberations, or whatever. So they can actually structure that to make it less intrusive. And judges are the best person to do this, because they're essentially the referee in the courtroom. They call balls and strikes. They admit or repress things by attorneys, and so they're kind of there to govern the process and make sure it's fair and impartial. So they also have some jurisdiction over the coverage. This reversed, of course, the prior Estes decision in 1965, and it rejected the idea that televising the trial actually violated the defendant's due process rights. And it should possibly help the trial's image, and they thought it could actually restore legitimacy to the court, because there was a concern that if it's not made available to the public, that there were secret dealings going on behind closed doors. So this is where we have actual legal context to say less intrusive television is permitted. Again, there are some qualifiers that go with this, and your text talks about that, but this is where legally we have to justify it. So in conclusion, with live television in courtrooms, now our concerns really center around the effect of courtroom cameras on those outside of the courtroom. Okay, so we worry about how people perceive or react to what happened on the case. So things like inciting riots in response to trial decisions, where we saw the Rodney King riots and the Ferguson riots more recently. Also the effect on victims who may be hesitant to report crimes because they see all this activity going on, and they start to think twice about coming forward. There is a concern that it may encourage copycat crimes, again, because of such intense and prolific coverage. Even though we've already talked about copycat crimes are not as big of a concern as we once previously thought they were. It does also have a concern of an effect on defendants found not guilty. So if you went through the trial process, which largely was not shown to the public, but just the highlights through the camera or the internet, you were found not guilty, but the public thinks otherwise, the public thinks you're guilty, you have to return to society. Even though you went through a legal process and that process was fair, it was not challenged, and suddenly you face all this social stigma. People treat you as if you were guilty, whether or not the court found you guilty or otherwise. So we think about, how do we ruin that person's life? You know, sometimes just being accused of something can ruin your life, let alone being convicted of it. Being accused of something can ruin your life because of that high social stigma or all that negative attention that follows you for the rest of your life. So again, the infotainment value is too great and the public interest is too high in what happens in the courtroom. And unfortunately, these kinds of concerns are really not severe enough to limit the coverage. So we're left with the television cameras rolling in the courtrooms and dealing with those aftermaths. So next we're going to talk about pretrial coverage and some of the rules that govern that. So now that TVs are permitted to be a part of the court process, we have to talk about what restrictions are at play and how all these things work. So we'll see you in part 3. Let me know if you have questions.